to the races. Get out my flag. There we go with the gavel. And welcome back, everybody. Once again, just 24 hours later, 22 hours later, here we sit once more with Bill C-10. And today, of course, we're doing a witness testimony. With us today, we have both ministers and officials. I'm just going to briefly introduce them for you. We have the Honorable Stephen Guilbeault, who is the Minister of Canadian Heritage, who's been here before. We also have the Honorable David Lametti, Minister of Justice. From the Department of Justice, we have Nathalie Drouin, Deputy Minister, Justice, Deputy Attorney General of Canada. Sarah Gay is Director General, Human Rights Law Section. Michael Himsel, Legal Counsel. And of course, once again, no strangers to us now by any means, Department of Canadian Heritage, Thomas Owen Ripley, Director General, and Drew Olson, Senior Director. Now, we have an hour and perhaps a little bit. I only say that I know we have an hour with the Minister, but Minister, bear with us. Sometimes we tend to go 5 minutes over. Sometimes I say that with trepidation, but we'll try. You can try to hold us to it. So that being said, we usually do 4 questions in the opening round, and we get to 4 questions in the second round. I'm hoping to accomplish that. If we have time left, we can do more. That would give us an extra 1 spot for the Conservatives and then the Liberals. But in the meantime, I'm going to try to hold to these 8 speaking spots. So that being said, we now have up to 10 minutes. Mr. Guilbeault, you're not doing an opening statement, but we understand Minister Lametti is. Minister Lametti, welcome to committee. And you have up to 10 minutes, and the floor is yours, sir.
Thank you very much, Mr. Chair. Good afternoon. Bonjour.
Good day, dear colleagues.
Today from Ottawa on the traditional territory of the Algonquin people. Thank you, Mr. Chair, for the invitation to appear before you to discuss the charter statement that was tabled for Bill C-10, as well as the explanatory document requested for the proposed amendments now before the committee. As you can see, I'm appearing alongside Minister Guilbeault, the minister responsible for C-10, and I'm accompanied by officials from my department.
I would like to begin by discussing my statutory obligation as Minister of Justice to prepare charter statements for government bills that are introduced in the House of Commons. I will discuss the purpose of the charter statements, their context and history. I will explain what the charter statements are intended to do, and I will discuss what the charter statements do not do. I am also pleased to discuss the charter statement that was tabled for Bill C-10, as well as the explanatory document that was provided to you and that deals with the potential impact of the proposed amendments on freedom of expression.
Note at the outset that it is not my role as Minister of Justice and Attorney General to give legal advice to parliamentary committees. You have access to your own legal counsel and independent witnesses. As you are aware, however, I do have obligations under the Department of Justice Act in terms of reviewing proposed government bills for inconsistency with the Charter and preparing charter statements for government bills. This obligation was created by our government to be open and transparent with Canadians about the Charter considerations of our legislation. These 2 sets of obligations, examining bills and preparing charter statements, are both focused on the bill as tabled. L'article 4.2
Section 4.2 of the Department of Justice Act requires that the Minister of Justice ensures that a charter statement is tabled in the House of Commons for every government bill. This requirement came into effect in December 2019. The review of legislation to detect inconsistency with the Charter under Section 4.1 is one of my most important responsibilities. Let me assure you that the obligation under Section 4.2, which is to ensure that charter statements are filed, is also an obligation that I take very seriously. I want to point out the purpose of charter statements. The purpose is to help inform public and parliamentary debate on a government bill. Charter statements promote transparency around the effects of the government bill on fundamental values that are protected by the Charter. They provide additional information to parliamentarians to further inform our important legislative debates on behalf of Canadians, and they provide additional information to Canadians to help them participate in these debates through their representatives. The obligation to ensure that charter statements are tabled reflects our government's commitment to respect and promote the charter as an integral aspect of good governance in our country. We can never abdicate our responsibility as a government to ensure that our decisions, including those reflected in law reform, respect our fundamental rights and freedoms. Section 4.2 of the DOJ Act reinforces the duty of current and future governments to meet this most basic obligation.
I would like to take a moment to explain a few moments to explain the content of charter statements. In keeping with their purpose, charter statements are drafted at a high level. They set out, in an accessible way, potential effects that a bill may have on rights and freedoms guaranteed by the Charter. Charter statements also explain considerations that support the constitutionality of the bill. In our discussion of the Charter, it is also important to stress that when Parliament legislates, it may affect charter rights and freedoms. This may include limiting their enjoyment or exercise when it is in the broader public interest to do so. This is entirely legitimate. The rights and freedoms guaranteed in the Charter are not absolute, but rather subject to reasonable limits, so long as those limits can be demonstrably justified in a free and democratic society. This means that when identifying a potential effect of a bill that it could limit a right or a freedom, it may also be necessary to consider whether the limit is reasonable and justified. A charter statement may therefore outline considerations relevant to the potential justifiability of a bill. The fact that charter rights and freedoms can be limited, however, is not a license to violate them. Rather, it is a reminder that any legislative limits to rights and freedoms must be carefully considered in the context of the shared values of Canada's unique, free, and democratic society. As parliamentarians, it is our responsibility to discuss and debate potential effects on charter guarantees. We exercise our judgment on behalf of Canadians as to whether proposed legislation strikes the right balance between rights and freedoms and the broader public interest. Charter statements are one more source of information to add to our deliberations.
I would also like to take a moment to explain what a charter statement is not. A charter statement is not legal advice. It does not provide a complete analysis of the constitutionality of a bill. As I mentioned, a charter statement provides the public and Parliament with legal information about the possible effects of a bill on charter rights, as well as the considerations that support the bill's consistency with the Charter. As we all know, bills often change as they move through Parliament. A charter statement reflects the bill at the time it is introduced by the government in the House of Commons. Under Section 4.2 of the Department of Justice Act, there is no requirement to update charter statements during the time a bill is being considered by Parliament. With that background, let me now turn to the proposed amendments to Bill C-10 that are before the committee regarding social media. My colleague, Minister Guilbeault, has discussed the scope of the proposed amendments. He outlined the important strategic objectives that these amendments are intended to achieve. And he discussed their desired impact on social media services and users of those services. In summary, the effect of the proposed amendments is that the Canadian Radio, Television and Telecommunications Commission would be able to regulate a social media service in relation to the uploading of programs by its non-affiliated users, only with respect to the payment of regulatory fees, for example, to support the creation of Canadian programming, the discoverability of Canadian creators, registration of the service, and disclosure of information and verification of records.
With my obligations under the Department of Justice Act, I tabled a charter statement for Bill C-10 in the House of Commons on November 18, 2020. The charter statement for Bill C-10 identifies the rights and freedoms that may potentially be engaged by the bill and relevant considerations that support the bill's consistency with the charter. In considering the committee's recent discussions focusing on the impacts of the proposed amendments on social media, I understand there has been extensive debate on freedom of expression. We have prepared and shared with you an explanatory document that examines the amendments and discusses their potential effect on the right to freedom of expression in Section 2B of the Charter. I'm confident that these considerations support the charter consistency of the bill and that they remain those outlined in the charter statement. It is our position that the bill as tabled and these proposed amendments are consistent with the charter. As the charter statement indicates, the bill's regulatory requirements have the potential to engage freedom of expression in Section 2B of the charter. The following considerations support the continued consistency of the proposed regulatory requirements with Section 2B. By virtue of Clause 1, which would remain in the bill, unaffiliated users of social media services would not be subject to broadcasting regulation in respect of the programs they post. What remains is an updating of the CRTC's regulatory powers and providing it with new powers applicable to online services. The bill maintains the CRTC's role and flexibility in determining what, if any, regulatory requirements to impose on broadcasting undertakings. Regarding the proposal to give the CRTC new limited powers to regulate an online undertaking that provides a social media service in respect of programs posted by unaffiliated users, the relevant charter considerations include the CRTC's discretionary role and flexibility. The proposed narrowing of the CRTC's discretionary powers to regulate a social media service in respect of programs posted by unaffiliated users to only discrete members that I have mentioned is an additional consideration. The CRTC is subject to the Charter and must exercise any discretionary powers it has in a manner that is consistent with the Charter. The Act states that it must be interpreted and applied in a manner consistent with freedom of expression. The CRTC's decisions on matters of law or jurisdiction are subject to review by the Federal Court of Appeal. In my view, the relevant considerations that are set out in the Charter Statement remain valid. These considerations are not impacted by the proposed amendments. Monsieur le Président.
Mr. Chair, thank you again for the opportunity to address the committee today. I will be pleased to stay with you to answer any questions you may have. Thank you.
Thank you, Minister Lametti. Okay, so now we go to our questions and comments round. As I mentioned earlier, we have 6 minutes from each of the parties. We're going to start with the Conservative Party. Ms. Harder, you have 6 minutes.
Thank you. Minister, in the Charter Statement for Bill C-10, Clause 3, Section 4.1 is cited as grounds for the Charter being, for the bill being in compliance with the Charter. Now, we know that that section was removed. Experts in the industry now say that the removal of Section 4.1 takes away the safeguards that were imperative to protect user-generated content. Do you agree with that?
Thank you for the question. As I said in my opening remarks, I'm not going to give legal advice. That is not part of my role as Minister of Justice. I don't give legal advice to committees. That being said, the Department of Justice has provided a further explanatory document that examines the amendments and discusses their potential effect on the right to freedom of expression in Section 2B of the Charter. And as I said in my opening remarks, I'm confident that the conclusion of that explanatory document is that the bill remains consistent,
Minister,
and the original charter statement has not changed as a result.
Okay. So what's interesting to me, and I appreciate that you're calling it an explanatory document because it's not a new charter statement. So thank you for acknowledging that. It is simply an explanatory document. And this committee did request a charter statement. So we'll get to that later. But Minister, my question for you is this. In the explanatory document, there's no acknowledgement of 4.1 being taken out. Why?
Again, I won't go into the mechanics of the explanatory document.
I'm just wondering
it took
why.
into account the changes. It's an explanatory document because the law only
but 4.1 is the whole
that
reason
I give
that it was
charter.
Requested. Why wouldn't you comment on that?
4.1, I do not have an obligation to give legal advice. I have an obligation to give a charter statement under 4.2. I did that when the bill was tabled, as is envisaged in the law. And we have provided an explanatory document. It's not a charter statement, but it takes into consideration the amendments that were made, and the original import of the charter statement remains true. That in our view, the proposed amendments are consistent with the charter.
It's interesting to me that in your opening statement, you said that the bill as tabled, direct quote, supports the charter. Again, giving no acknowledgement to the fact that 4.1 has been removed. And even now, as I'm asking you questions, you're skirting the issue. You're refusing to address the fact that 4.1 has been removed and give a statement as to whether or not it still is charter compliant. Why are you avoiding my question?
I'm not avoiding the question. In fact, I've answered it, and I answered it in the opening remarks. The explanatory document looked at the proposed amendments, and
including the removal of 4.1.
It is, yeah. Well, including all the proposed amendments and the bill as tabled.
You're skirting again.
According to the explanatory, I'm not skirting anything.
Why won't you just address it? Why won't you just say? Then why not just say yes? 4.1 being removed still respects the charter.
I have said that all of the proposed amendments, including that, are consistent with the charter according to the spirit of both the explanatory document and a charter statement.
Okay.
Remember, Ms. Harder, that I'm not here to give legal advice, and I can't give you legal advice.
I'm not asking for legal advice. I'm asking for the reflections of a very qualified minister.
You have,
and I certainly would expect you to be able to answer my questions directly without skirting them.
And I am answering the question.
I'm going to move on to my next question.
I'm not skirting anything.
Dr. Geist makes it very clear. He says there is simply no debating that by removing section 4.1, the bill now applies to user-generated content, since all audio-visual content is created as a program under the Act. Do you agree with that? Is that a correct statement?
Well, I believe you're quoting Professor Michael Geist is the proper pronunciation, and I will defer to my colleague, Minister Guilbeault, to answer that question.
It's okay, Mr. Lametti, the question was for you. So if you'd prefer not to answer it, you can just state that publicly.
I'd be happy to answer the question.
The question was for Mr. Lametti, and it is my time, so I do get to direct it to the witness of choice.
Okay, everybody.
Mr. Chair, I would remind the honourable member, Mr. Chair, that I'm here to answer questions with respect to the charter statement.
Minister Lametti,
yeah.
if you could just, can you hear me? I'll just be 1 second.
I can indeed hear you.
Ms. Harder, as you know by now, you can direct a question to a particular member, that is true, but that person is not compelled by anyone here to answer that direct question. They're not even compelled to be here, whether they be an MP or a senator, and it's the same practice we have in the House of Commons.
Mr. Chair, may I?
Go ahead, Ms. Harder.
Sure.
Is this part of my intervention or part of...
It is about your intervention. I do understand what you're saying. I know that Mr. Lametti doesn't have to answer my question, but at the same time, when we have other witnesses here, one witness doesn't get to pass the question on to another. It is up to the speaker to determine which witness is being asked the question. So if Mr. Lametti doesn't want to use my time to answer the question, he doesn't need to, but he doesn't get to pass it off to Minister Guilbeault.
But Ms. Harder, with all due respect, witnesses of the same organization pass it amongst each other quite often. And ministers have always, at least in my 19 years of being here, close to 19, they've always gone to officials as well. It's just something that we do. I understand you're frustrated. I used to get frustrated too. I know where you're coming from, but I just... But
if I may...
just one moment.
Mr. Chair, may I clarify one thing, Mr. Chair?
When I'm ready.
It is...
Just one moment, please. I just want to make sure that everybody understands those rules about directing questions before we get into something else. I've stated it now. Ms. Harder had wanted to make a point, and I'm going to, do I proceed with your testimony or your questioning, Ms. Harder?
I just wish to clarify one more thing about your direction that you're giving as chair right now.
Go ahead.
Your ruling is different than what it has been in the past, and I'm not sure if that's because we have two ministers in front of us. In the past, you've given us the latitude to determine the witness to whom we are directing our question.
That is correct. But if you direct it to a particular person, they can refer to someone else. You can talk to whomever you wish, but the person receiving the question can refer to someone else if they so desire. I can't compel them, even if I wanted to. So I'm sorry for your frustrations, but I'm trying to make my way through this, and I'm hoping that nobody talks over each other. So now, Minister Lametti, you had something you wish to clarify as well.
It's a long-standing practice of the House of Commons and committees, Mr. Chair, that ministers speak to their own bills.
I
I'm
appreciate
here for
that.
a specific reason to speak to the charter statement, and that's what I will do.
And you mentioned that in your opening statement, but now I have to proceed. Ms. Harder, you still have the floor. Go ahead.
Minister Lametti, I think as I've already expressed, I know you to be very capable, very competent. I know you to be a strong defender of free expression online. You've certainly written to that effect and made statements to that effect. And so I was very glad that you were here today. And I do have a question with regards to discoverability and its requirements within this bill. Again, Dr. Geist, he said that in his view, the prioritization or deprioritization of speech by the government through the CRTC necessarily implicates freedom of expression. Based on the charter statement that you produced, would you agree with that?
As I have stated, the conclusion in both the charter statement and the explanatory document is that the bill is consistent with the charter. If you have a question on the applicability or a particular point of interpretation in the proposed bill, I will turn over the floor to Minister Guilbeault.
I have a question with regards to the charter. So as to whether or not Section 2B of the charter is actually held up by this bill. So let me explain further. If I go to an art exhibition owned by a private individual, I expect to walk in and for the art to be curated for me. Some artists are going to be given the front room, other artists are going to be given a back room. The curators are going to choose which paintings come first and which are towards, maybe the end of the exhibition. That curation is expected because I'm going into a private gallery and they've offered to do that for me. At the same time, however, if the government was to come in and dictate to that gallery how the art should be hung or where it should be hung or which artist should be promoted, that is censorship in its finest. The same thing is happening on our social media platforms with Bill C-10. How does that fit within Section 2B of the Charter to have what we post online carefully curated and censored by a government arm, the CRTC?
As I had mentioned in my opening statement, both the charter statement and the explanatory document looked at the various provisions of Bill C-10 and found that Section 2B might be engaged, but there were various reasons given, which I outlined in my opening, to conclude that this was in conformity with freedom of that this was in conformity with Section 2B of the Charter. Again, if there's a substantive application question, I will turn it over to Minister Guilbeault.
Thank you. I have to turn it over to Mr. Housefather.
Thank you, Mr. Chairman. Minister Guilbeault, it's great to see you here again. Thank you, and thank you to Mr. Ripley and the officials from Heritage. And I want to particularly thank Minister Lametti and express my personal appreciation to him and to Maître Drouin and to the team from Justice for being here today, which is outside the normal course. Minister Lametti, this committee had asked you to provide a document focusing on whether the committee's changes to the bill have impacted the initial charter statement provided, in particular as relates to Section 2B of the Canadian Charter of Rights and Freedoms. Somebody is trying to use a technical term in terms of what we're calling the document to tell us whether or not you have delivered. Do you believe the document you provided delivers exactly what the committee requested?
Yes, I do. It answers the question that was posed by the committee, which was, did the analysis contained in the original charter statement change with the amendments? And after the analysis, the explanatory document says that no, that is not the case.
Thank you. And at our meeting last Friday, a number of questions were raised about why the explanatory document was not on the Department of Justice website, why the initial charter statement had not been amended on the Department of Justice website. Can you explain to us why that's the case?
The legal obligation with respect to charter statements, according to Section 4.2 of the Department of Justice Act, is that they be tabled around the time that the bill is tabled in the House of Commons. At that point, we put it up on the website. As the committee requested a separate assessment, we produced an explanatory document based on the amendments to C10, and we gave it to the committee because it was the committee that requested it. It's not the charter statement that was originally tabled, and so there was no need to list it on the Department of Justice website.
Thank you. And some have claimed that the charter statement is a political document because it's signed off by yourself, who happens to be a Liberal minister. Would it not be more accurately described as a non-political document prepared by non-partisan department officials at Justice to provide Canadians and parliamentarians with a better understanding of how a bill may impact charter rights?
That is very true. Your second characterization is absolutely the case. The first characterization as a political document is absolutely not the case. It's an important responsibility, as I outlined in my opening remarks, for me to oversee the preparation of charter statements. These are done by nonpartisan department lawyers whose task it is to prepare charter statements and to do the analysis. The charter statement has a specific role, as I outlined in my opening remarks. And while it is a document that is finally reviewed by me, I do that in my role as Minister of Justice, and I do that very seriously in a nonpartisan way. And the document itself was drafted in a wholly nonpartisan way. So no, it's not a political document. It's meant to be a legal framework document, if you will. That's the best way I can describe it.
And I know that you said this, but I just want to make sure we're all clear on this. In reference to the explanatory document, is it accurate to say that you have determined that the bill as amended and proposed to be amended does not change the relevant considerations in the original charter statement?
Yeah, that's precisely the conclusion of the explanatory document. The relevant considerations as set out in the charter statement remain valid, and these considerations are not impacted by the proposed amendments. It's exactly what the conclusion is to the explanatory document.
And some criticize the charter, the explanatory document for not stating whether the potential discoverability requirements would breach Section 2B and require a Section 1 analysis. Mr. Minister, would a charter statement ever contain Section analysis?
Very rarely, if ever. I certainly can't recall ever having seen one with a Section 1 analysis. The reason is that when you get into a Section 1 analysis, you're balancing the actual, you're balancing the actual provisions in an act with a section of the charter, and you're asking whether it's justified potentially as a limit that's reasonably and demonstrably justified in a free and democratic society. That's something that puts you in the realm of a political analysis or giving an actual legal opinion. And in either case, it is not something that would be in the neutral framework of a charter statement. And so I personally think I would never see one. I can't recall ever having seen one. Putting the Section 1 implications do not have their place in the charter statement, whose goal, as I've already set out, is to articulate the articles that might, under the charter, that might be impugned by a potential piece of legislation, and the considerations that are there that explain the law.
Thank you. Mr. Chair, do I have any time left?
Yes, you do have about 30 seconds.
All right, Mr. Minister, a quick question. Would you agree that the charter statement carefully considers that any regulations made by the CRTC on the discoverability issue, including with respect to algorithms, would have to respect the charter, including Section 2B, as opposed to the social media companies themselves who do not have to respect the charter in their use of algorithms?
Again, both the charter statement and the explanatory document took into account all of the various changes that went into the act, and we have concluded that there wasn't a change in the original conclusion of the charter statement. If you would like a more precise answer on the content of the actual act, I will turn the floor over to Minister Guilbeault, whose responsibility it is to explain and defend the bill.
I think I'm out of time, so I'm not sure that would be the case, but thank you.
Yeah,
thank you very much.
Actually, I'm registering a few seconds. So sorry, Mr. Guilbeault. I apologize. We'll have to get to you, work that answer in at some point during the deliberation. Monsieur Champoul, pour 6 minutes, s'il vous plaît.
For 6 minutes, please. Thank you very much, Mr. Chair. Thank you to the ministers for being here today. Minister Lametti, earlier in your opening remarks, you spoke about certain cases where the freedom, and let's say that the freedom of expression is not finite. There are limits. Can you give me an example of cases where it would be justified for freedom of expression to be limited? Where would that be appropriate?
Merci.
I thank my colleague for the question. Despite the fact that this is an important question, I am here to explain the function of charter statements and the explanatory document that we provided. I am not here to give a class about the charter, especially not to give legal advice, but Mr. Minister, and that is a hypothetical question that could be very risky for me as Minister of Justice. So if you have a question about C10, I will give the floor to my colleague. No, Minister, my question was related to something that you yourself said in your opening statement, in your opening speech. So I was hoping you could simply elaborate on what you said earlier about how freedom of expression is not absolute. Of course, there are times when it is appropriate to limit it. I wanted you just to go into further detail. I don't want legal advice or anything. Do you have any examples you could give? Well, I'm not going to give examples, but as I said in my remarks, that is obviously the case. Freedom of expression is not absolute. There are numerous examples in many areas of law where the rights set out in the charters, the charter in Quebec, the charter in Canada, where those rights are limited by other laws and other regulations. The objective of the charter statement and what the charter statement does is to have a general look at the bill in relation to the charter. And in the charter statement and in the explanatory document, the conclusion that we've reached is the following. And let me say that the charter is not specific, so my answer will not be either. So you're talking about or rather, this is not necessarily legal advice, but you are a lawmaker. So can we talk about how C10 might be passed in Parliament? In that situation, the bill is voted through and is eventually brought into effect. Certain Canadians feel that freedom of expression can be threatened by certain parts of the bill. Could those people go before the courts to say that this was a threat against freedom of expression? Well, that is always a possibility, and that is one of the reasons why I do not give legal advice publicly, either here or in the House of Commons. But as I have said repeatedly, if you have a specific question about the scope of Bill C-10, I will pass the floor over to Mr. Guilbeault. No, I think that the bill didn't have to do with Bill C-10. We have a good example here. We have a bill that is more complex than just the matter of freedom of expression. So I'm wondering about, after the bill is passed, would it be possible to challenge certain components if someone, for example, was concerned? I'm just asking you a simple question about the way justice works. Yes, that is the case. Okay, thank you. I'd like your opinion on something, Minister, and perhaps I could put the question to Minister Guilbeault, who's also with us. Do you feel that there's something that could be added right now to Bill C-10, wording of some sort, that would assuage people's concerns about the perceived threat to freedom of expression? Do you think something would resolve this matter once and for all? I will give the floor to Mr. Guilbeault. Yes, that is a question for Mr. Guilbeault. Thank you, Mr. Chair, and thank you to my colleague for his question. Of course, the committee has sovereignty to propose amendments that the committee feels will enhance the bill. And from the outset, I was the first to admit that all bills can be improved. We are a minority government, and of course, the opposition parties can make proposals, and we have accepted many of your amendments in the past, and we remain open. Thank you. I think we'll come back to that. I think I'm out of time. Thank you.
Merci, Mr. Champoux.
Thank you, Mr. Champoux.
Person for 6 minutes, please.
Thank you, Mr. Chair. I would also like to take a moment to thank the ministers, both Minister Guilbeault and Minister Lametti, for being here today, and for the department representatives from Heritage and Justice for joining us today on this important meeting. Mr. Lametti, I'm very glad you're here. I have to say that I was worried when you initially chose not to testify for this committee. I was, of course, deeply concerned that your absence would cause continued delay and would continue to impede our work creating good broadcasting legislation. So thank you for taking the time to be with us here today. Mr. Lametti, some experts have stated that your latest update on the charter statement is very fragile, as it is more a political document to protect the mistakes of your government than a legal analysis. So, of course, by declining the initial invitation, we felt that you were reinforcing this concern and fears about the threats to the freedom of expression. So again, thank you for making the time to be here with us today. I have some questions for you, a series of questions for you, if you don't mind. First of all, I'd like to know, can you identify the sections of the bill that are intended to protect the charter principles? So could you identify clearly those provisions that are intended to protect the charter principles?
Again, thank you for the question, and my absence was based in part on a principle that ministers defend their own bills in front of committee.
Pursue a bit of a different role within this government.
Yes, but it would be a terrible precedent if a minister of justice were called to defend charter statements. In part because they are apolitically drafted, in part because, as you have identified in your question, they aren't meant to be a legal opinion, and so there are going to be differing legal opinions out there, and you as a committee, you as individuals, parties, other people for or against proposed legislation can get access to legal opinions and go precisely into detail. The charter statement isn't meant to do that. The charter statement is a framework document that is meant to show that the government is attuned to the fact that there is a charter and that proposed legislation needs to conform to that charter, and therefore forces the minister in charge of the bill, forces the Department of Justice and the Minister of Justice to take all of that into account. If you wish to go through a more specific analysis of the various articles of the bill that are in question, I would turn the question over to my officials. I did identify the changes that were brought about that were considered in the explanatory document subsequently And again, the conclusion is they fall within the original framework of the analysis that was done in the charter statement.
Thank you. Well, and I don't think I'll go into more depth at the moment, but one of the concerns that I have with this legislation, and I've articulated this many times at this committee, is that if this initial bill is, we know that it wasn't crafted particularly well and that we have had to have 120 amendments come forward. If we don't fix this legislation, if we don't make sure that this legislation, which we know is decades overdue, is done properly, it will be challenged in court. You just alluded to that potential just in your last answer. And if that happens, the implementation of this bill will be delayed again and again. And of course, the impact is going to be felt by the Canadian cultural sector. Those that this bill was meant to help will actually hurt them the most. So as you know, several experts have said that your department's analysis does not provide a clear answer regarding the bill and its compliance to the charter principles. If the protections are not clear, what would happen if the bill is challenged in court? And further, I guess, do you think that without clear protections for the charter principles, there is a high risk that a legal dispute will undermine efforts to protect our cultural sector?
Thank you for that question. Look, I support the bill. I'm a member of this government and this cabinet, and I support the bill. So let's make that clear from the outset. The charter statement is meant to help frame debate. It's meant to help identify articles in the charter that might be engaged by a piece of potential legislation, and to identify the considerations that might be looked at as an explanation of the bill. It is not meant to be a legal opinion. And so you're absolutely correct in your question to note that there are going to be legal experts who say there isn't enough in a charter statement to say that the bill is completely in conformity with the charter. That's never the case with any charter statement. And there will be differing legal opinions depending on the weight of that any particular legal scholar, commentator, lawyer puts on any particular factor. And so I leave that to lawyers. Legal scholars, and other experts to do that weighing in the public sphere. The court system is part of this process, but obviously, I certainly would like, as a legislator, that this committee help improve the bill, and that my colleague puts forth a bill that is a great bill. And as I said, I support this bill, and I wanted to make that clear.
Thank you.
And Mr. Chair, if I may add.
Sure.
No, I have one quick question very quickly. I know I'm running out of time, but as a legal expert with your own legal opinion, Mr. Minister, are you confident that the provisions of the bill are strong enough to ensure victory for the government in the courts? What is your opinion? I realize that there are different opinions, but in your opinion.
I will. Yeah, I thank you for the question, and I appreciate that it's given that it's posed as a compliment. I simply don't give legal advice in public, particularly not after having been named Minister of Justice. So I appreciate the question, but
thank you, Ms.
I won't give opinions.
I appreciate the free flow conversation, but unfortunately I have to be more rigid than that. We're now going to a second round. I'm going to be a little bit more strict because we're running out of time. Monsieur Reyes.
Mr. Reyes, for 5 minutes, please. Thank you, Mr. Chair. And thank you, Minister, for having agreed, finally, I should say, to come and speak to us at the committee. I'm very pleased. I want to ask a very simple question to begin. Section 2B of the Charter, does it protect the freedom of expression of individuals and their content? Yes or no? Mr. Reyes, thank you for the question. Obviously, as I've said since the beginning of the meeting, I am not here to offer legal advice or opinions. That is not my role today. That is something that I never do publicly. It is true that in general, Section 2B does protect freedom of expression, but I will not get into the details in a hypothetical way. That is not my role today. Mr. Lametti, with all due respect, you are Minister of Justice. My question is simple. The Charter of Rights and Freedoms, a public document. This is my personal question. When we have a charter does the charter protect individuals or what individuals say? you mentioned in your opening statement that there were some limitations. You were not open to specifying. That's okay. It's your prerogative. And I don't think I'm asking you for a legal opinion here. I would just like to be reassured that the Charter protects individuals and their content. True or false, really. Simply. If you can't answer that, well, I can't give you examples. Yes, I'm able to answer a number of legal questions, but as Minister of Justice, I'm not allowed to answer. Okay. It's not my role today. I'm here to explain the Charter statement, the role of the minister in relation to that, and the explanatory document. Okay, perfect. Thank you, Minister Lametti. Yes, you explained that you are under no obligation to answer our questions if you don't want to. I understand that you don't want to tell us that Section 2B of the Charter protects individuals and their content. Is that what I'm understanding? You don't want to tell us that. So your Charter statement that you tabled on November 18th of last year included in its analysis, it specifically included 4.1, which was withdrawn about 3 weeks ago from Bill C-10. That is the very basis of the complicated situation we are in. You are Minister of Justice, so you can't give a legal opinion, but experts have come to speak to us. You said earlier that perhaps lawyers, etc., after the bill is adopted, would be able to give opinions, but we've already had experts come and talk to us. We have a number of CRTC former officials who wrote an article yesterday in the CRTC, and they explicitly said that the bill would already be challenged. We already know it will be challenged. There are concerns on the part of political analysts, university professors. And we are MPs. Our job is to make recommendations and to bring forward the concerns of those experts. So why was Section 4.1 there in the beginning? To protect content. Then why was it withdrawn? And how can we now feel reassured that content is still protected? How can I, as an MP in the House of Commons, make a recommendation if you, the Minister of Justice, won't help me?
Merci pour.
Thank you for the, well, I think there was a question in there. Here's what I can tell you. In the original Charter statement that was tabled when the bill was tabled, concluded that Bill C-10 was in compliance with the Charter. And I explained this in my remarks and in my answers to questions. Now, with the changes that were made to Bill C-10, we provided an explanatory document whose conclusions were the same following analysis. If you have specific questions, you can always ask those to Minister Guilbeault because it is his bill, and he is responsible for answering those questions. And if you wish, I can give the floor to him. You answered my question.
But the time dictates I can't give him that time right now. Mr. Lewis, 5 minutes, please.
Thank you very much, Chair. And I thank Ministers Lametti and Guilbeault for being here. I appreciate that. And also want to thank the representatives from Justice and Heritage for being here and this important conversation. You know, we've heard lots of testimony already, and numerous arts organizations have come out in support of Bill C-10. And, you know, our artists are among the most fierce defenders of free speech in our society. And they understand that updating this Broadcast Act in no way infringes on the freedom of expression, nor does it represent any censorship of the internet. So, Minister Lametti, I would like to hear from you in explaining the balanced approach that this bill takes, like supporting our arts and defending free speech. Specifically, in the Charter statement, it says, in making regulatory decisions, the CRTC must proportionately balance the objectives of the acts with protection of freedoms of expression in light of the facts and circumstances. So can you explain exactly what you meant by that? And is it your conclusion that the original import of the charter statement still applies and remains true? Minister, I believe you're on mute.
Very sorry. Thank you for the question, and I thank you for regaling us during late night votes with your musical skills and your voice. The charter statement does, Mr. Lewis, discuss the regulatory decision-making process of the CRTC, and does, as you have said in your question, cite the balance that it has to achieve. I would add, as part of the charter statement, and it's indeed quoted in the charter statement, that the Commission is subject to the charter and therefore must exercise its discretionary powers in a manner that is consistent with the charter, and the Act. So therefore provides that the Act must be interpreted and applied in a manner consistent with freedom of expression. So that's contained in the charter statement. If you want to delve further, I'm going to give you the same response that I've given to our other colleagues around the table, which is I will turn the floor over to Minister Guilbeault to give further precision.
Thank you, Minister. And in that vein, I forgot to mention off the top, I'd like to share my time with Mr. Bruce, and so maybe she can pick up the conversation from here.
Perfect. Well, in fact, I don't know how much time I have, but I would like to be able to give some time to Minister Guilbeault to respond. I know that he has indicated a couple of times he wanted to say things, and I think that given that it is so important to move forward to clause by clause, we've heard from so many of the people in the creative industry about the importance of this bill, and from witnesses yesterday as well. I believe the minister might have something that he would like to add.
Thank you very much, Mr. Chair. Thanks, Mr. Bruce. And earlier on in one of her questions, Ms. McPherson said that because the bill had around 100 amendments, it was a flawed bill. That's a false premise. I know, just like me, she's a new MP, so we're not used to this, but it's not uncommon for bills to have 200 amendments. Going back to the previous Parliament bill, I could recall Bill 69 that I followed closely in my previous career, had around 200 amendments. So there's nothing extraordinary about that. In fact, 100 may not be so much after all. And she pointed out that we've heard about experts that have raised concern. I think just yesterday, this committee heard from a number of experts who have actually clearly said that they thought that there was no issues regarding freedom of speech. We've heard from a previous director of the CRTC, Janet Gill, from a law professor from Université de Montréal, Pierre Trudel. And I could quote, because I don't think it's been done in this committee, and I think it is important. It's in French, so I'll switch to French, but the unanimous resolution from the National Assembly, I'll just quote a quick phrase, but constitue une avancée
is an important advancement for protecting and promoting Quebec culture, and as a result, the National Assembly of Quebec approves.
Bill C-10 actually has a lot of support across this country for the benefit it will bring to our artists, but as well to the broadcasting ecosystem as well.
Okay. You have 24 seconds left if you...
I think that I can leave the 24 seconds on the table.
Mr. Champoux.
Mr. Champoux, for 2 minutes and 30 seconds, please. I'll take 2 minutes 54. I'll take Ms. de Bruzen's remaining time. Mr. Guilbeault. You're fully aware of the impasse that we're experiencing right now and the reasons behind it. And I think that we're justified in questioning ourselves in this situation. We had experts yesterday who were the polar opposites when it came to their points of view. The conditions that we came to an agreement on was that the committee asked for a renewed, updated charter statement and for the Minister of Heritage and Minister of Justice to appear. However, we did not receive a revised charter statement. We received an explanation of the charter statement, and we received the Justice Minister a few days late. Mr. Guilbeault, my question is that do you think that your team is taking this bill seriously? Thank you to my colleague for his question. In fact, I feel that we have done everything that the committee asked. Every time the committee requested for me to testify, I came to testify, especially over the past 2 weeks. You asked for specifications and clarifications regarding the original charter statement, and that was tabled last week. My colleague, Minister Lametti, the Minister of Justice, is here with me today. We take this bill very seriously, and I think so does the entire cultural and art sector in Quebec and Canada. I'm sure you saw the Union des Artistes statement. There was Ariane Moffat and other artists. And there was an article in the Toronto Star last week as well. Unions again today, the FTQ, which is the major labor union in Quebec, Unifor, the biggest Canadian union. Yes, you don't need to convince me of the urgency and the relevance of this bill. I think we all agree on that. My concern, my worry is that your team is not reinforced enough. Well, you can come and help me. Well, that was my question. Or Adam Van Couverton could help.
Merci. Bon.
Merci beaucoup, tout le monde. Okay, Ms. McPherson, two and a half minutes, please.
Thank you, and I would like to thank the ministers and their staff for coming again. Just very quickly, I want to point out that while Mr. Guilbeault has pointed out that many organizations have been supportive of this bill, I would also say that I met with hundreds of individuals and organizations, and not a single one said that this bill was strong as it was. That every single organization recognized the urgency, but every single organization also said that this was a flawed bill that needed to be fixed. So I did want to have that on the record. Minister Lametti, I guess I have a couple more questions for you. No, you may not, actually, because I'm just going to ask Mr. Lametti some questions, if you don't mind, with my very short time.
Ms. McPherson has the floor. Go ahead, Ms. McPherson.
From the drafting of the bill until now, have you used independent legal analysis of the government to ensure that the bill and the amendments your government has made are consistent with the charter principle?
We, in the Justice Department, we provide, our lawyers provide legal opinions. They provide them both to me, they provide them both to other ministers and ministries, and they are used in the drafting of legislation. The contents of those documents are protected by solicitor-client privilege.
So sorry, was that, so no independent legal analysis has been obtained?
Occasionally there is independent legal analysis obtained for a variety of different purposes. Again, those documents are covered by independent by solicitor-client privilege, as indeed is the fact that we may have asked for advice in the case of any particular bill. That too is also covered. The actual asking and the solicitor-client relationship is also covered by solicitor-client privilege. So I wouldn't.
So you can't tell us if you've got any.
That's right.
Have you considered any proposed amendments that strengthen the bill's compliance with the charter principles?
It is the minister in charge, Minister Guilbeault, and his team who would assess amendments and proposed amendments, and who would go over their legality with justice lawyers, either embedded in the Heritage Department or within the Justice Department, as the case may be. But it is entirely up to Minister Guilbeault and his team.
Thank you, Minister. That's all for me. Those are the questions that I have. Thank you, Mr. Chair.
Thank you, Ms. McPherson. Okay, folks, that brings us to the end of this part. This is the witness testimony that we brought here today. We want to thank both ministers for being here. We want to thank their officials who accompanied them as well for being there as well. Is there any further discussion at this point about what we have heard? Seeing none, other than Minister Lametti waving goodbye to us. I'm assuming that's what he meant. Okay, so as you saw by committee business, tomorrow we are going, not committee business, sorry, but as you saw in the notice, tomorrow we're going to resume with clause by C10. I'm looking for input here. We're good to go. As in the motion put forward by Mr. Housefather has been satisfied, and tomorrow we will proceed as we did. We're going to be starting, by the way, if you're keeping score, G11.1. That's where we start off with. Okay. Oh, sorry. Monsieur Reyes.
Mr. Reyes. Thank you, Mr. Chair. I just have a small question that I would like to raise in front of everyone. I have the motion by Mr. Housefather here in front of me. In part 1 of the motion he tabled, which he wrote by himself, it asks the Minister of Justice to provide a revised charter statement on Bill C-10. The minister specified in his speech and in many answers to questions, and not only from the Conservative Party, but also questions from other parties, that it was not a revised charter statement, but instead an explanatory document. So I would like to know the opinions of committee members. Did we all agree? Did we all understand what was asked, what was said by the minister? Here is the third point in the motion. It says that clause by clause of Bill C-10, until points 1 and 2 have been satisfied, cannot continue. So I'm wondering, I don't know what our decision will be, but I have good discussions that I plan to have with my party, and I'd like to hear from other parties.
Okay. Thank you for that, Mr. Reyes. Mr. Housefather, go ahead.
Yeah, Mr. Chairman, I certainly hope we don't get into this semantic argument. Under the Department of Justice Act, Section 4.2, a charter statement can only be produced at the stage of the bill being introduced into the House of Commons. So it can't be called a charter statement under law because our law tells us what a charter statement is. It doesn't provide, as I had argued and explained before, for something called a new charter statement or a modified charter statement. We asked very clearly for something that would explain to us whether the amendments we made to this bill impacted the original charter statement, particularly as related to freedom of expression, and we received it. If we're going to argue because it couldn't be called the charter statement, but rather is called a declaration or whatever, that we haven't fulfilled the motion, then at this point, it is a deliberate attempt to filibuster the work of the committee. It is a deliberate attempt to thwart the work of the committee and never to get back to clause by clause and never to finish the bill. So I will take great exception, having drafted the motion, to any argument that the motion was not fulfilled. It absolutely was fulfilled. Thank you.
Okay, Mr. Housefather, before we go to Mr. Champoux, yes, as chair, I would like to have clear direction, or at least good, solid direction from the committee as to where we go from here. We are in the middle of clause by clause. We're now fulfilling the motion of Mr. Housefather. I would like to ask the committee for direction from here as to whether we have received or satisfied what was put forward by Mr. Housefather, and we go ahead. But I do want to expand this conversation. Let's go to Mr. Champoux.
Merci.
Thank you, Mr. Chair. Look, that was just about the same question that I was asking to Mr. Guilbeault earlier. Because yes, we did ask for a revised charter statement. With that said, despite this raised eyebrow, if I can say it like that, we did receive an explanation of the charter, and it does answer all of our questions. We also received the ministers. We also heard from experts who enlightened us considerably, even if not all of their opinions were unanimous. But we also heard from legal experts that defended their own points of view. So personally, I am fully satisfied, Mr. Chair, and I wish for us to continue our work. I think we have received the answers we asked for.
Ms. Harder.
Thank you. This is more than semantics, as Mr. Housefather would describe it. This is asking for specific information. It's the content of the statement that was created. I think, as the Conservative Party at the table, we could get over the so-called semantics. But what was requested, and I'll just read it back to the committee, was that that we would ask the Minister of Justice to provide a revised charter statement on Bill C-10 as soon as possible, focusing on whether the committee's changes to the bill relate to content uploaded by the users of social media services have impacted the initial charter statement provided, in particular as relates to Section 2B of the Canadian Charter of Rights and Freedoms. So in other words, it's the acknowledgement that there is potentially an impact that those amendments have had on the content. The motion is very specific. It says the impact on the content that users post on their social media platforms. That being the case, in the statement provided by the minister, he does not actually address that. So what we have in front of us is I would liken it to an individual going to the doctor, getting a clean bill of health, going out, smoking 10 packs of cigarettes a day for the next 10 years, but still claiming that he has a clean bill of health, pointing back to what the doctor gave to him. No. There are some factors, very significant factors, that have been changed since that original charter statement was granted. And so we can get over the wording, whether you want to call it a charter statement or an explanatory statement, whatever, but the content of that document needs to address what our motion as a committee put forward. And that is, we want to know, is it charter compliant to censor the posts put on an individual, put on social media by an individual? The explanatory statement does not address that.
Ms. McPherson.
Thank you, Mr. Chair. I believe, very similarly to my colleague, Mr. Champoux, that we had ministers attend this committee and answer our questions. We had experts come and answer our questions. We have had opportunities given to reflect upon the statement that was provided. I think this is a complete tactic being used to delay us doing the work that we've been tasked with at this committee. I would deeply like to get back to work. I would deeply like to fix what I see as flawed legislation and move forward. I do not want to spend the rest of this session filibustering and listening to certain members of this committee talk ad nauseum so that we can't get our work done. I think it is well, the next step needs to be to continue our work. Thank you.
Thank you. Ms. Harder, Ms. McPherson, can I get you to just lower your hands? What can I say? I'm easily confused. Mr. Champoux.
Oui, encore moi, monsieur.
Yes, me again, Mr. Chair. I wanted to specify something. I asked a few questions about what could possibly happen legal challenge-wise, after Bill C-10 was passed, if there were still concerns about the constitutionality. And he said that there's always an accessible process in place for Canadians, and either individuals or groups, to challenge the constitutional validity. Mr. Chair, something has been said very clearly over the past days by the leader of the Conservative government. He has clearly said that if he were to be elected, he would repeal this bill. So, when it comes to Bill C-10, our Conservative colleagues have zero support for our bill. There has always, however, been a lot of constructive work, despite the fact that the Conservatives may be against this bill. This is an extremely important bill for the cultural sector, and repeatedly we have expressed how urgent this is for the cultural sector. I repeat, we have fulfilled what was asked for in the motion. I know we'll never reach a consensus, but let's agree to disagree, and let's continue to do the work that we must do. And court challenges will always be possible afterwards if Canadians do feel that part of this act is a threat to freedom of expression. Our job is to deliver as much as possible on this bill. We must send it back to the House of Commons. The culture sector is waiting for us. They're watching us and they're imploring us to get over this impasse and continue our work. I think it is crucial, Mr. Chair, for us to get past this impasse.
Merci.
Well, thank you, Mr. Chair. I have to say that I want to see this bill get moving along as well. And I was surprised when we hit Clause 3 in Section 4.1. There was a Conservative Party amendment to that. And after that amendment failed, there was a move to remove 4.1. There was no debate. There was no call for a recorded vote. We didn't deal with that section at that time. And we're stuck in this ongoing filibuster. We've seen that the minister has come, he has given an explanation. We should get through the rest of these amendments. There is a stage at the report stage where this section 4.1 can be added back in. And if enough parliamentarians think that that's an important thing to have added, then that's what we should do. I believe in freedom of speech as much as the next person, but I find that the whole system of algorithms with these private platforms doesn't really lend to freedom of speech anyway. I get countless emails from constituents who say that there isn't freedom of speech on Google, on YouTube, on Facebook, and that their comments are being blocked or that things are being blocked. And so that's another issue that we need to deal with. We're dealing with private platforms who are censoring people and determining what gets bumped up and what gets bumped down. And it's mostly for commercial interests and about advertising and to inflame people, to weaponize our anger at each other. And I think that we need to look at this, and we're coming up to Bill C-11, where we're going to be talking about these things, but we should get this Broadcasting Act done. And if there's an amendment at reporting stage to fix and bring back 4.1, that would be the time to do it. Let's get the rest of the amendments through.
Mr. Aitchison.
Thank you, Mr. Chair. I think, what I'm hearing people talk about here with the motion that Mr. Housefather put forward, I think I could probably accept that at the bare minimum, we have scratched the surface of meeting the terms of our motion. I accept Mr. Housefather's explanation of what can and can't be called a charter statement. I'm fine with that. But as we get back into this bill clause by clause, which we're destined to do, I hope that everybody just keeps in mind something that Minister Lametti did in fact say, and this is, I guess, the crux of it for Conservatives and for me particularly, anyhow. And that was his comment in his statement where he talked about some limits to the charter to freedom of expression may be justifiable. And so we know that the removal of 4.1, we've heard that it does actually implicate some limits of freedom of expression. And I don't think we've ever really truly had, like Mr. Manley said, we never really had a healthy discussion about specifically 4.1 when it was actually removed. And I would just hope that everybody would go away from this meeting and think very seriously about how much freedom of expression are you prepared to limit, with an ambition to make sure that the government regulates what Canadians see online with some policy of trying to promote what they deem as most Canadian versus what Canadians actually choose. To me, that's a fundamental question worth debating. How many limits how much of our freedom of expression should we be prepared to give up to make sure that Canadians are forced to see what we determine Canadian choices first online? So I just hope that we have that discussion as we go forward, because I don't think we really adequately have had it.
Mr. Reyes.
Mr. Reyes.
Merci, Monsieur.
Thank you, Mr. Chair. My friend, Mr. Housefather, I saw you turn red. I was wondering if you ate some lobster right before you took the floor. I don't want to make you angry in any way. I was simply answering the chair's question, and it's not an insult. I want you to take what I said as a joke. I was just answering the chair's question when he asked me what was going to happen next. I put the question there to ask for other parties' opinions. You are all committee members. I feel that the 3 points were not fully respected. You disagree, you have the right to say so. Insisting on things, well, I do understand this is heated. We're all tired. It's the end of the session. It's an important matter. And God knows we Conservatives are on the receiving end of our fair share of attacks. But 4.1 was removed, and Mr. Housefather's motion is asked for the charter statement. And his motion was just about the same as the one that we had already tabled 2 weeks before. So I don't want to say anyone that we're delaying, because we could have used our original motion. With that said, on those remarks, Mr. Chair, I think that you have heard the answer to the question. In any case, we will meet tomorrow. We're going to make our decision amongst our party members. You will all do the same. And I would like to ask for adjournment if no one else would like to take the floor. I don't want to stop anyone from speaking, but I think that we have finished with this subject, Mr. Chair, and we'll be pleased to meet tomorrow.
Just to clarify, Mr. Reyes, are you moving an adjournment?
Yes, but only once everyone has had the chance to take the floor, because I don't want to cut anyone else like I did with Mr. Champoux one time.
Mr. Reyes, I can't accommodate both. I can only do one or the other. I'll assume that you did not move the motion because you just out of the corner of your eye saw Mr. Housefather with his hand up. So I'll assume that you didn't move that motion, if I may be so bold as to suggest. Thank you. Mr. Housefather.
Oui, monsieur.
Yes, Mr. Chair. I just wanted to assure my colleague, Mr. Reyes, that I'm a fan of his. I was not angry at him or at the Conservatives or at anyone. I completely agree that we have worked very well together right up until we got to Clause 3, and we must continue. Mr. Chair, I think that you can conclude that at least there is a majority amongst committee members that we can continue clause by clause tomorrow.
To repeat that in English, I think we clearly saw there is a majority on the committee that wishes to proceed with tomorrow and move to clause by clause. So I hope that we can then do that, and everybody can reflect over the night over how we can best get through clause by clause, starting with the amendment that Mr. Bruson had on the floor when we left clause by clause. And I wish everyone a good evening, and thank you for listening.
I appreciate your closing remarks, but I still have Mr. Champoux. Mr. Champoux.
J'ai beaucoup apprécié.
Well, I really appreciate Mr. Reyes' kindness not to want to not give me the floor like last time. I will now propose the adjournment motion, please.
And that sounds to me like an actual motion. Motion to adjourn. If anybody has an issue with adjourning, please say or raise your hand or say no. As you know, we're in the world of negativing things in the virtual world, so there is a motion put forward to adjourn. Seeing no resistance, so done. Meeting adjourned. See you tomorrow.